as the newish director of the research department at the ETUI, is on the European Pillar of Social Rights and the way forward for social Europe. And we have three distinguished academic speakers addressing us on this issue. The first one is Professor Tonia Novitz from the University of Bristol Law School. She will be presenting on a place for collective labor rights in a sustainable, strong social Europe for just transitions, which is a topic that slightly laterally, Tony, I should say, already emerged as an important topic in one of the earlier sessions this morning. The second presentation is from Professor Luca Ratti from the University of Luxembourg. He will be presenting on something that has attracted a lot of his time and attention in recent months since his successful funding bid. Working yet poor and the European Pillar of Social Rights, how in-work poverty became the priority for EU labour law and social policy. Our third speaker is currently having some minor technical problems and is trying to reconnect, but it's a colleague from the University of Padua, Paolo Graziano, and he's presenting on the end of the relaunch of Social Europe, ? Reflections on the current state of EU social policy affairs. So without further ado, I'm going to give the floor to Tonia Novitz. Tonia, you have 15 minutes, and I will be reminding you that you have 5 minutes left just before the end of your presentation. Thank you.
Thank you very much for inviting me to join this conversation today. I think there's a PowerPoint that should be coming up. Is it? See if, can you see it? I can't see it yet.
It was visible before, and now it's disappeared.
Okay.
Yes, we can see it now.
Okay, fabulous. That's wonderful. Thank you. So, as Nicola said, I'm talking about a place for collective labour rights in a strong social Europe for just transitions. And I want to start with thinking about the European Pillar of Social Rights, which really seemed to offer renewed recognition of the place of collective labour rights in social Europe as part of the sustainable development of Europe. Principle 8, as you know, stressed social dialogue and involvement of workers. It emphasized consultation of social partners on the design and implementation of economic, employment and social policies. But more than this principle sought to actively encourage negotiation and conclusion of collective agreements while respecting their autonomy and the right to collective action. Now, coming in the wake of the battles in the International Labour Organization over the legal basis for protection of the right to strike, and after the controversial cases of Viking and Laval, the pillar looked like good news. So in this brief paper, what I'd like to do is explore what is happening to the protection of collective labour rights subsequently, with reference to the sustainability objectives of the new Commission in the policy framework of a European Green Deal. In this respect, I'm going to be focusing on the Commission communication of 2020 on a strong social Europe for just transitions and its apparent manifestation in the Commission proposal for a directive on adequate minimum wages. There will no doubt be much more to come, potentially on digital services and a post-COVID recovery plan, but that's my focus for now. So, sorry, I've gone ahead of myself. So before I get underway, I want to present 3 claims which I've made earlier in other contexts. The first is that sustainability is not only concerned with green objectives. It has environmental objectives for sure, but also economic and social objectives. Now, these are likely to interact and in many contexts will be interdependent, but they are also severable. So it's been recognised in the 2015 General Assembly Resolution on Agenda 2030 adopting the Sustainable Development Goals, that social sustainability is deserving of its own attention. And, just to take briefly an example, prevention of child labour as manifested in SDG targets 8.7 and 16.2, that doesn't have any obvious or immediate environmental aspects, but it's vital from a sustainability perspective when we're reflecting on the needs of present and future generations. So I think it's worth bearing this in mind when we're constructing a case for collective labour rights, that it's important to do so not just from an instrumental perspective. This is not just a way to perfect green objectives, even climate change objectives, but there is also social sustainability, which is served by collective bargaining rights. My second point is that the achievement of sustainability objectives, environmental or otherwise, is a dynamic process. It doesn't just require expert advice, but active engagement by stakeholders, including worker representatives. And they can then operationalize technical data, translate that into workable action. That has tended sometimes to be constrained to mere formal consultation in the shape of social dialogue. But it's better for trade unions to be equipped and enabled by law to bargain and take collective action in pursuit not only of workers' immediate needs, but their long-term objectives. So Frank Hendricks this morning asked in the first session, is climate change a bargaining topic? And my answer to that is emphatically yes. Yes, it is. And to do that would be compatible with Principle 8 of the Pillar. It would also be compatible with the SDGs, and that's been pointed out quite recently by the UN Special Rapporteur on Freedom of Association in 2018, and also by the International Labour Office in its report Time to Act for SDG 8 in 2019. The third claim I want to make is, and I think it's important to remember this, is that it was the trade union movement which created and developed the idea of just transitions, both at national and international levels, which is now going to be operationalized through the Paris Agreement of 2016 and the European Green Deal. A just transition strategy can have various elements, and that's evident from the tripartite 2015 ILO guidelines, but collective bargaining remains vital. I think it's so important we don't lose this nexus, this connection to trade union activity as a touchstone for making acceptable changes. Cementing and improving EU protection of collective labour rights is all the more important at this time when massive changes may need to be made to industry and services to address the need for a post-COVID reconstruction in ways that address green, but also other sustainability objectives. So, having outlined the normative basis for my analysis, I want to go on and talk a little bit about the Commission communications for the European Green Deal and a strong social Europe for just transitions. Now, the Commission communications on the European Green Deal and a strong social Europe for just transitions have been analysed initially in an excellent ETUI publication by Sebastian Sabato and Boris Frontedo. And they indicate how the EGD can be reconciled with ILO just transitions policies. But I have to confess that when I read these two communications, my first response regarding protection of collective labour rights was that this was disappointing. Why was it disappointing? Well, the Green New Deal communication made reference to citizens' dialogues and social dialogue, but it seemed to me that collective bargaining was left out of the picture. There was reference to capacity building, which could be relevant to trade unions, but it wasn't clear how that would be operationalized. The Strong Social Europe communication was intended to set out the road towards an action plan to implement the European Pillar of Social Rights. and we know that should be presented in early 2021. Overall, there seemed to be an assumption that the social partners would work together with the Commission on new technologies, demographic change, and green policies. This constituted unions as stakeholders in important ways, but it didn't seem to suggest real scope for more conflictual engagement in collective bargaining and collective action on these important issues. And that, for me, is a break with the earlier conceptions of the bases for just transitions. Funding and other concerns might be met, but collective bargaining seemed to be left to one side. There was an exception, which was on pages 8 to 9 of the communication under the head of fair working conditions. So there was reference to the significance of collective bargaining there, first in relation to a fair minimum wage, and then in relation to platform workers in the new Digital Services Act. There was also a helpful, much more general reference to the capacity of unions and employers' organizations to engage in effective social dialogue and collective bargaining and their significance for fair working conditions. There was no reference here to collective action or a right to strike, nor was effective protection of collective bargaining referred to explicitly in the external relations section on promoting European values in the world. But we might expect, because this is one of the ILO core labour standards, that it was merely assumed that this was included. But both communications seem to me to be a tactful step back from the broader stance, the bolder stance that was there in Principle 8 of the Pillar, and adopted on the very same day that the Pillar was, we had new Article 1A of the Posting of Workers Directive, protecting the right or freedom to strike as a fundamental right. That seems to have been left out of the equation subsequently. And I think I may not be alone in that disappointment, given the call of rapporteurs in the European Parliament Committee on Employment and Social Affairs for broader coverage of collective bargaining and appreciation that collective bargaining, they say, is at the heart of functioning social market economies. They've promoted attention to collective representation and protection of the rights of health workers and social carers, a broader class of precarious work than just platform workers, and also cross-border and seasonal workers, particularly in a time of COVID-19. So what are the initiatives that are being proposed subsequently in 2020? Well, at the end of June 2020, consultation was launched in respect of collective bargaining for the self-employed and the platform economy as part of a wider Digital Services Act package. This is pretty much as promised. And that raises questions as to whether gig workers can be generally regarded as workers under EU law, which is interesting following the order which came out of a preliminary reference in the case of Yodel. And it's prompted speculation as to the ways in which accommodation might be made under competition law, even if they're not deemed workers. Arguably, that's a potentially promising follow-on from the SSE communication, and it does accord with the ETUC's objective of widening trade unions' representation, although it can also be seen perhaps as something of a delaying tactic in that respect. More interesting for now is the more concrete proposal for a directive on an adequate national minimum wage. And briefly, because I probably don't have that much more time, one issue here has been opposition by Scandinavian and Nordic unions, which see statutory regulations problematic when collective bargaining is their way of ensuring adequate wage setting. The Commission has responded with a measure, I think, that seeks to be sensitive to the competence constraints in Article 153, paragraph 5 of the Treaty on the Functioning of the European Union, which, as you know, excludes from social policy competence pay, the right of association, the right to strike, or the right to impose lockouts. The draft directive is instead based on Article 1531 of the TFEU on working conditions within the boundaries of subsidiarity and proportionality. And the idea is that as the proposed directive does not set pay and only promotes collective bargaining, so competence issues are evaded. What I think does look promising is the positive duty on member states to promote collective bargaining in Article 4, even though that's limited just to wage setting. It looks to promote capacity, so capacity building coming through from the European Green Deal communication, and to encourage constructive, meaningful, and informed negotiations. This is not stuck in a consultative social dialogue frame. It looks more like Principle 8. When collective bargaining coverage is less than 70%, the member state is to establish an action plan to encourage collective bargaining, either by law after consultation with the social partners or by agreement with them. Public procurement can now be on the basis of compliance with wages set out in collective agreements for the relevant sector and geographical area under Article 9, bypassing what might have seemed to be the apparent limitations of the Reggio Post decision. There are also reporting obligations arising under Article 10 on the rate of collective bargaining coverage, and implementation can be undertaken by the social partners. Now, this is a more proactive and promising model for an approach to the COVID-19 crisis than we saw in the wake of the global financial crisis of 2008. And that was observed in a recent excellent UK labour law blog by Zoe Adams. As she notes, the proposed directive also reflects the benefits of having wage agreements tailored to the needs and conditions of particular sectors and occupations. The directive has also been cautiously welcomed as a crucial first step in a Social Europe blog by Torsten Muller and Thorsten Schulten, where strong collective bargaining is no longer viewed as impediments to flexibility and competitiveness. They also make the case that there should be additional safeguards written into the directive. Protection against victimization, although I think that is to some extent at least covered by Article 11 of the proposed directive, and a right of access to the workplace, which I agree is overdue in many countries. Now, I am curious as to how one can have recourse to meaningful negotiations without any background threat of lawful industrial action, but I think that brings me to my outstanding concerns. So I do wonder what EU actors can do in more concrete terms to secure these collective labour rights, especially the right to strike, the right to take collective action, given limited social policy competence. And as was mentioned today at various stages, that is an old problem. Another problem that remains, of course, and this reverts back to platform workers, is who gets access to collective bargaining. If we think about the proposed directive, it seems to be just the standard EU worker, which might well be a missed opportunity. And that's important in terms of the commitment that no one gets left behind, which is evident in the preamble to UN Agenda 2030, the UNGA Assembly resolution, and the European Commission's communications. There is arguably a lack of joined-up thinking here regarding platform workers. And I guess finally, I would welcome the specific attention to collective bargaining in the context of wages and platform workers. I think that's an important acknowledgement of the significance of social sustainability. But I suspect the specificity of the measures envisaged by the Commission to date really only takes us so far. We need to think more about collective bargaining in terms of the larger aspects of the European Green Deal, broader multifaceted sustainability issues, and the restructuring, reskilling, and redundancies that may be involved in the future debt recovery that follows from COVID-19. In this respect, it seems vital that unions can assist in negotiating just transitions more generally in the labour market. And so there's a strong case here for more careful and coherent attention to collective bargaining rights in a broader context. And I think we're still waiting on that. So I will finish here. Thank you.
Thank you very much, Tonia. Thank you. That was genuinely excellent and as ever, thought-provoking. Luca, the floor is yours. You have 15 minutes.
Thanks. Thanks, Nicola. Thanks to all to the TUI for this very welcome invitation. Now I will use some pictures as presentation, not really a lot of text, so you will excuse me. But I would like to talk today of a very brand new but very old issue at the same time, that of inward poverty in the EU. It's a new one because, to be honest, in labor law it was historically left to the realm of social security only. But at the same time, it's probably one of the most deeply rooted preoccupations of policymakers in our field, since the working poor laws were in fact enacted at least since the 18th century for the working people who struggled to make ends meet. I will start doing this from let me now put this on a slide, from a beautiful view on the seaside in Sicily. It was there where in 1955 6 men of goodwill met to agree on the Messina Declaration, which read that, and I quote, "The establishment of a united Europe must be achieved through the development of common institutions, the progressive fusion of national economies, the creation of a common market, and, last but not least, the gradual harmonization of their social policies." A second picture helps me setting the scene. It is just one amongst the many across the EU, picturing the desolation of poverty. And that was the focus of the first 3 poverty programs developed by the European Commission from 1975 to 1994. Then other poverty programs went on. And a third picture comes from Brussels, and it was taken yesterday morning thanks to Instagram. This is the EU Commission today. And with this, we have to admit that for the first time so evidently, the EU government has put the reduction of inward poverty rates at the core of its political action in the field of social policy. Now, today, I would like to understand how this happened, employing 3 distinct dimensions: reality, policy, and the law. Just look at reality. If we look at reality, we must admit that already during the years of the Jacques Delors Commission, so 1985, 1995, there was some attention to 2 concurrent objectives: the need to boost employment and that of reducing poverty in the European economic community. But inward poverty started to be put under the radar of the Commission only a decade later, when Eurostat released the new indicator, and more precisely when in 2003, they adopted the inward poverty risk indicator, which was to be measured, and I quote, as the share of individuals whose most frequent activity status is that of employed and who are at risk of poverty, meaning who live in a household that equivalent income is below 60% of the median equivalent income of the whole population, the so-called poverty threshold. The same reality, therefore, only needed to be better understood, since it is very, very much likely that inward poverty in Europe was already in the 90s and in the years 2000 at worrying levels. However, it was only in 2010 when the Barroso Commission committed to Anthony Atkinson and Eric Marlier the study on income and living conditions in Europe. The 2 researchers later on continued their cooperation, the study of the EU SILK system. And the 2010 study remarked the importance to target 3 different situations in which workers were involved. The activity situation, in which more than half of the reference period, at least 27 weeks, was at stake. The employment situation, where at least 1 month of work was at stake, and the working or in work situation, when at least 7 months were at stake. With these three situations, inward poverty rates were measured. And now we are in 2020, 10 years have passed, and I would say 10 summers with the length of 10 long winters. And reality recorded by Eurostat tells us that inward poverty today has risen sharply. And now let me show some more meaningful pictures. Sharply from 2010 to 2016, and slowly started to decline in the last 3 years. Now, of course, 2019 data are the latest one available, and current predictions and surveys show a completely different scenario. But for such reality to be recorded, we still need one more year, probably even more. And that was reality. But what about policy? Which steps has the EU undertaken to overcome, or at least to take into account, the rise of inward poverty in Europe? Well, some would simply say zero or not that much. But to be fair, we must recall that for decades, the EU's obsession has been that of jobs, jobs, jobs. This is particularly true for the Barroso Commission, but it's fairly applicable also to the previous Prodi Commission. This gave rise to an unprecedented rise in employment rates, with the parenthesis, of course, of the 2012 financial crisis. But it's important to note that it did not give rise to an equivalent reduction of poverty in general, and neither of inward poverty. When we kicked off our WorkApe project in Luxembourg last March, we had a remarkable lecture by Yves Marx, who remarked that job growth generally brought increases in work-rich households, which were stronger than the reductions in workless households, or better to say, in households with lower work intensity and income. This made clear, particularly with the Europe 2020 agenda, that employment rates remain a key indicator, but also income distribution and the combat of inward poverty should be given sufficient policy attention. And this was made very much concrete, especially starting with the Juncker Commission. If we read the President's speeches, and some references have been made this morning as well, on the State of the Union from 2014 to 2019, we immediately realize that the strive of that Juncker Commission to reach what the President defined as an EU with a triple social A. And Juncker's perseverance in this direction is our EU pillar of social right, which has been so far extensively analyzed. My take on this is the following. For the first time in an EU programmatic document, inward poverty is addressed, and it is addressed as a standalone issue of social policy and not flagged under different or more reassuring labels such as upward social convergence, the combat of social exclusion, and so forth. Now, if we look at proposition number 6, for example, the pillar makes clear that inward poverty shall be prevented. And it does this in the light of the principle of decency enshrined in the first limb of the same proposition number 6, as well as, I would say, under the umbrella of the principle of dignity, which is expressly mentioned in proposition number 14, for which everyone lacking sufficient resources has the right to adequate minimum income benefits, ensuring a life in dignity at all stages of life. Is this the end of the story? Is this the final point? I would say definitely not. Because one of the main effects or consequences, if we want, of the pillar in the legislative field, and I'm now going to my conclusion on the law part, is the current proposal for directive on adequate minimum wages across Europe. As Tony already mentioned, this is a very important step, probably not a sufficient one, but at least it must be welcome. The proposal was formulated by the von der Leyen Commission from the very start, after the termination of Commissioner Schmidt, and although the 2 rounds of consultation have been so and so, and although the social partner decided and made clear that they did not wish to negotiate an agreement per Article 155, we have some important points. Amongst the many technicalities that are in the proposal, I would like to mention its preambles here. We all know that the preambles are anything but ornaments. They have a strong interpretative value. Well, in such preambles, and once again, let me show them one important to you. There are 3 preambles which mention inward poverty. The first 2 ones, so number 4 and number 5, are more, formalistic, if you want, and refer to proposition number 6 of the pillar, as well as the Council decision 2020-15-12 on employment policies for the member states. The real important reference here is preamble number 7, which more directly states that minimum wages contribute to sustaining domestic demand, strengthen incentive to work, and reduce wage inequalities and inward poverty. The Directive on Minimum Wages, therefore, aims at establishing a causal link between the adequacy of minimum wages and the reduction of wage inequality and inward poverty. Now, existing literature finds that the impact of an increase in minimum wages only would not have a significant role in reducing inward poverty. It contributes for sure to tackle wages inequality and to sustain wages and income of low-skilled workers employed in low-wage sectors. However, as a standalone policy, minimum wages is not enough. But saying it's not enough is very different than saying it is useless or superfluous or even detrimental. That's why it must be welcomed from my perspective as an extremely positive initiative from the Commission, which political significance goes very much beyond the merit of the proposal. And now I come to the very conclusion. It should, however, and probably will, be accompanied by other important legislative initiatives that are also needed to help reducing inward poverty. I will list some of them, all of which are crucial from my point of view. Introducing a minimum income scheme at EU level, reinforcing child benefits across the EU, reforming some rules on flexible and precarious work contracts, ensuring certain levels of work intensity, i.e. banning or limiting the use of zero-hour contracts, and covering the self-employed with social security and income protection measures. All in all, the next years will be positive or possibly bring important novelties of inward poverty. As my partners from the EAP and the European Poverty Network keep on saying, the combat of inward poverty is not an impossible task. On the contrary, it is essentially a political choice. It is for policymakers, therefore, and in our field, for the social partners as well, to make it happen. So for the time being, let's see what comes out from this proposal on minimum wages, and we will do our best to strengthen on the other points. Thanks very much. But Nicola disappeared, right? So if I may, I could give the floor to Paolo, right? Yeah, just go
yes,
on.
I think so, yeah. Nicola is coming, but maybe, yeah,
No
maybe
worries.
Paolo can go on with the presentation.
Hi. Sorry, it happens even in reliable internet conditions that systems fail. Luca, thank you very much. You had an extra minute, and I was indicating you had an extra minute, but clearly that was the minute I took in order to re-log in. So thank you for that. And our third and final speaker for this session is Paolo Graziano from the University of Padua. Paolo, I briefly introduced you before, but I think at that point you were having some problems with your internet connection. But Paolo is presenting on the end or the relaunch of Social Europe, a rather provocative question. We're very much looking forward to hearing from him about his reflections on the current state of the EU social policy affairs. Thank you, Paolo. The floor is yours. Paolo, we cannot hear you. You're muted. Paolo, we cannot hear you.
Yeah, can you hear me now? I was supposed to be not muted. Okay, good. Yeah, so very good. I was just saying that I would like to thank you for the invitation, and I also thank Tonia and Luca for their presentations, because they allow me to be a bit more broad, and I will not go into some of the details that have already been said and discussed. And I also wanted to apologize for not being here for the entire conference, because this morning, as you all know, the academic world has been stormed by COVID-19, and we continue to have meetings and trying to understand what to do. So I'm really sorry I couldn't be more participative, but again, thank you. I'll try to share four main reflections that are building on what Tonia and Luca to a certain extent said, and I really want to thank them also, because they really allow me not to go into the details that they already discussed in a number of ways. So the first reflection regards the content of the EPSR, because it has been also mentioned to this previously. We have to recall that the EPSR is the European Pillar on Social Rights is really something that at the beginning was seen as a symbolic change in terms of what the policy evolution had been for several years. There's no need to go into the details of what happened to a social Europe between 1997 and 2017. Everybody is very well aware with what happened, but in a nutshell, I think it cannot be, it should be emphasized that the pillar was a very, very important symbolic affirmation of the relaunch of social Europe. Now, being quite critical in some contributions of what social Europe has become until recently, also I was a bit puzzled by the first discussions that we had between 2015, 2017 in Brussels in a number of fora, where it did seem that the European Commission was preparing something very novel. But at the same time, it seemed to me and to several other colleagues that have been following the European Employment Strategy, the open method of coordination, it seemed that we were somehow reinventing the wheel. And this, at least initially, made me a bit skeptical about this document. I fully acknowledged the relevance in symbolic terms. But at the same time, I was very skeptical that there would be a follow-up in terms of proposals and directives. So 3 years later, I think that we can say that, yes, actually, the European Pillar of Social Rights has really been an attempt of a new beginning. An attempt of a new beginning, because if you look at the 20 propositions, some of which have been already referred to, you have 10 that are almost entirely devoted to social policy issues, social affairs. And with this respect, it's quite novel with reference to what also Luca was reminding us earlier: jobs, 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 or employment-centered social Europe. Because for 20 years, roughly 20 years, we had an evolving discourse that was actually advancing in the European agenda with reference to employment affairs, but was not saying that much with respect to social policy. And again, we don't need to go back to the 1998, 2002, 2003 period, when it seemed that the open method of coordination could be very expansionary, because it seemed that it would have applied to healthcare policy, to pension policy, and to social assistance to a certain extent. But then after mid-2000s, we all know that the policies that were pursued by the European Commission, and more broadly speaking by the European institutions, went increasingly in another direction. So first reflection, 2017 is really an attempt to launch something that is new, also with reference to how social policy, social Europe was defined before that year. Second reflection, and it deals more with the reasons why it was an attempt of a relaunch of social Europe. My reading, together with other colleagues, of this first relaunch of social Europe, which had some very noble features, deals with the fact that Europe was trying to cope with a very, very peculiar series of critical junctures. And of course, the 2008 crisis has been already referred to, but we should also recall the 2015 migration crisis. So 2015, 2017 were moments when you had a European Commission that was trying to make its own mark in a novel way. So to a certain extent, the Commission tried to use the critical juncture, the critical moment, we don't need to explicitly refer to the literature on critical juncture. We could just use a more broad term, a critical moment that actually offered a window of opportunity for the European Commission. And the European Commission actually tried very much to use it, exploit it. But what was quite striking in that period was that within the European Commission, many of those that had been involved in social Europe in the past were actually not there anymore. So what was a bit striking in that period, when you did see something new coming, and you did have a critical juncture, a critical moment that could have allowed ambition to be really on the front page, somehow you had to go back to discussions that, I'm putting it a bit bluntly here, but what is the open method of coordination? What were the developments of the policy? Because it was quite awkward to be in a room discussing with some people that were going to work on the EPSR, that had to be reminded that we had in 1997 something that was the European Employment Strategy. Now, again, I'm being a bit provocative here, but it's just to say how the critical junctures or the critical opportunities, the critical moments that may be turned into opportunities also require an administrative infrastructure that allow the attempt to relaunch to become actually a relaunch. Because otherwise we will remain in a potential relaunch, and to a certain extent the EPSR wonderful declaration is a potential relaunch, but then we need to follow up and have people that are capable of doing this. And here again, the critical juncture has been, I think, very useful also for the new Commission, and therefore I'm much more positive in terms of reading the dynamics within the European Commission in terms of having things happen. These 2 or 3 years have been years very complicated, especially the last year for obvious reasons, but I do see a follow-up which is very promising in terms to supporting the potentialities of the relaunch. So the second reflection is that not only do we have a symbolic document that could have been seen as a mere symbolic exercise, but actually 3 years later we do see how the critical juncture has been used to a certain extent. Again, I think much has still to be done, and both Tonya and Luca were very clear in underlining things that have to be done in the future. But again, let's not forget that we are really in a peculiar moment. So I do see some evidence that shows that actually it's going to be transformed growingly into a real relaunch and not simply a potential relaunch. And this leads me to the third remark, which is more linked to the politics of social Europe. Now, technicalities and policy provisions, of course, are of great importance, but we also, I think, have to be very frank in understanding how complicated the politics of social Europe have always been, and in particular are now, after a decade of austerity in a number of countries. So when we think about the politics of social Europe, we have to think about the multi-level politics and how somehow the new beginning needs to be integrated into a power dynamics which is in line with the preferences of the European Commission. Let me put this a bit more simply. The potential relaunch that is currently transformed into something much more promising, concretely speaking, is still very much in the hands of the European Commission. And we have proposals that, again, are going in the direction of making the potential relaunch something real. But as we all know, and if we go back to the discussions, the conferences that we had in Brussels between 2015 and 2017, we have several countries that continue to be very reluctant with reference to a growing level of government that is related to employment affairs still and to social policy. And of course, the usual suspects are always there, but we could, I think, also see more and more countries that are tempted, especially in the current situation of healthcare emergency, are tempted of going back to renationalization. So with this respect, we really need to take into consideration the political dynamics, the current political dynamics. And this is why, going towards the end of my intervention, I am not so positive that the potentialities will be fully transformed into reality, because we have somehow a gate that has to be overcome, which is the domestic politics gate on the one hand, and the domestic preferences gate that then, once uploaded in the European Union, may water down many of the proposals of the European Commission. Of course, this is not new at all. So the multi-level politics of the European Union have been there since 1955, as Luca was telling us about Messina, to a certain extent, very, very ambitious, but at the same time, very complex. So we need to monitor very carefully the power dynamics, and to a certain extent, if we take a very normative perspective, we must encourage, support the European Commission in order to continue in the path that has been drafted and designed so far. Final remark regarding the future steps. Again, we had something potentially new in 2017. I think we do have some signs that potentialities are translated into something real, but we have also the potential obstacles that may be put forward and actually have been already put forward by a number of governments. So, fourth remarks regard the future. And here I think the European Commission has a key role in remaining coherent in its policy proposals. And here we have to open up the box and not only focus on social Europe, but also on other policies. And the Green New Deal is clearly another opportunity, because it has to be connected very powerfully, very strongly to the social policy agenda. And we, again, do have some signs of policy integration. We do have some signs of policy coherence. This is very important. But I think that it's in the hands of the other stakeholders, to use this language, to make sure that the European Commission does not change his path, and even more so, to support that part of the European Commission that has been doing so much in the past 2 years. Because let's never forget, we all know this, and I'll conclude, but let's never forget the European Commission is also very, very fragmented in its own right. And one of the lessons that we learned with reference to the past is that the social component of the European Commission has been put on the side with reference to other more financial and budgetary based components. So I do think, to conclude, that we do have, for the first time in a long, long while, we do have some evidence that we're going in the right direction for social Europe, and the EPSR may really deliver. But we still have some obstacles that we have to be very careful of. Thank you.
Thank you very much, Paolo. Thank you very much to all the panelists in this session. You've been outstanding, both in contributing ideas that have clearly triggered some interest, and certainly have some questions from our audience, and also in leaving time for these questions to be answered. So without further ado, I'm going to report to you, there's at least two questions that have really emerged in the question chat. The first one is, I think, clearly linked to the last point that you were making, Paolo, one of the last points that you were making, but I think it's a question also that other colleagues could answer. How much of what we are witnessing in this change of direction is linked to the pillar, okay, and how it was originally conceived, and how, you know, the content of the pillar, but how much of it is also linked to apparently external forces, for instance, the current Commission. You know, in the past, we've had some great instruments that will not follow through by the governing institutions of the European Union. You know, the Charter of Fundamental Rights of the European Union was proclaimed with completely different expectations to what it eventually delivered. So how much is it really endogenous to the pillar? How much is linked to important but transient political dimensions of the issue? One of the questions, I think, Tanya was also alluding to, you know, Brexit perhaps as being a force for good. You may not feel that way, the other side or this side of the channel, in focusing people's mind around, you know, deeper levels of discontent in European society, demanding a change of direction. So this is the first question or range of questions that were prompted by your presentations. I would like all of you, if you have a chance, to answer or engage with them. Thank you. Perhaps we can go in reverse order. We can have Paolo, Luca, and then Tonia.
Okay, if you wish, it's fine by me. Well, thank you for the questions. And actually, we did not really consider the EPSR as the main and unique sole trigger of changes. But clearly, I think that we should consider the fact that there's a political entrepreneurship going on here. And clearly, the new European Commission, in the critical juncture, that was a critical juncture where clearly we had several countries trying to push forward different agendas, and we had an opportunity. The opportunity was to open up new policy windows for the European Commission as such. So on the one hand, we had the environment, which was strongly supported by social movements, and was also strongly supported by scientific evidence. It was becoming increasingly problematic. And on the other hand, we still had the echoes and the continuation of the crises, the 2008, 2009 crisis, that actually had still, were still playing a role 10 years later, because some economies did not recover. And there was this need in the Brexit, and this leads me also to the second point, in the Brexit scenario, this actually led the European Commission to be much more focused in terms of the policies that had to be at the heart of its agenda. But let's never forget that policy cliffs are needed. I call them policy cliffs because it's something, or policy hooks, as you want to call them, because somehow they allow political entrepreneurship to be much more ambitious. So we could argue that the current European Commission, without the EPSR, would have not been able of going so speedily into a very clear direction. And therefore, the policy, in other terms, the policy legacy helped the current European Commission to really go directly into the details without doing all those all that work that was needed between 2015 and 2017 to prepare the EPSR. So it's clearly both endogenous and exogenous. So I do think that the European Commission, if we take it as an exogenous, but I would have some doubts. But anyway, to use the terms that have been used, then it's endogenous in terms of the EPSR already being there and being a hook that could be used by all the actors in order to support social policy goals. On the other hand, if we went back to a Barroso Commission, of course, nothing would have happened. So yes, we need to acknowledge the fact that we do have a commission and we have a president of the commission that since the beginning has started to underline the potential relevance of social Europe. But again, my argument is that it was possible due to the previous work done by the Commission on the one hand, and due to the continuous work done by several other stakeholders that have been really participating into the making of EPSR. So it would have been very difficult just to ignore it and do something else. Therefore, we have some entrepreneurship, but let's say that the capital that was already there, the social capital that was already there, was very, very important. And finally, very briefly on Brexit, I will leave this to other colleagues. Clearly, as we all know, Great Britain has always been against social Europe in a number of ways. But I would not overemphasize this point because currently we have within the European Union a number of countries, and clearly most of them are the newcomers in the European Union, that have a limited interest in greater regulation for obvious reasons. So yes, Brexit could have maybe simplified slightly the pathway, but I'm not sure, actually. I don't think that the United Kingdom was the only obstacle. I think there are many others, and these actually others are becoming increasingly vocal.
Let me pick up just a few things from the questions, particularly the part I will leave Brexit entirely to Tony, unfortunately for her. Let me pick up just the aspect about the policy, the 2019 policy recommendation on social protection for all. I think this initiative, which per se might be positively welcomed, must be seen in the period at the end of the last commission, in which the pillar was giving its first effects. And we should not forget that there are three big and important initiatives that were put forward by the Commission pretty much at the same time. The renewal of the recast Posting of Workers Directive, the Transparent and Predictable Working Conditions Directive, and that on social protection. That was also supposed to be a directive, but there was no political consensus on this. So if we look at the 2019 recommendation in this slide, I would say is not that much. First of all, it's quite contradictory. It's in its consistency, or better to say, in its inconsistencies internally. Secondly, it's a recommendation. So if the question is what the member states are going to do, well, probably not that much. For sure, the good and bad news, it depends. The new point in 2020 is that what we are experiencing now outside of the window is that all governments are taking care also to the self-employed as if they were workers, or pretty much in a similar way, so that they are putting in place some measures already of income protection, almost quasi social security, meaning that probably involuntarily, this crisis prompted a renewed attention of national governments towards the self-employed. And I will just conclude on this. From my perspective, so from the perspective on inward poverty, we should never forget that the self-employed are one of the clusters that are mostly affected by inward poverty. So I think that a step forward by member states should be very much welcome also in this respect.
Luca, in a way, you have already anticipated the next question I was going to ask you specifically, because it was addressed to you, somebody from the audience agreeing very much with what you said, but also saying that clearly what the European Pillar of Social Rights has not been able to intercept at the moment is the self-employed, the claim for universal labor and social rights, or as the author of the question puts it, the pillar of a universal worker. But I think the point that you've made, feel free to add to that. Tells me that you're thinking that the COVID crisis is starting to push things in that direction.
Yeah, true. There's only one aspect that shouldn't be forgotten, is that about the heterogeneity of the self-employed as a category. That's something that we as labor lawyers we're not used to deal with such huge thing. I know you're doing like this for sure. What is at stake there? It's that the non-protected self-employed should be taken care of. So normally the solo self-employed, or the gray zones categories and so on.
Thank you, Luca. Tonia?
Yes, okay. Thank you very much to the other presenters. I've thoroughly enjoyed listening to you, and I have to say I would pretty much endorse everything that you've both said. The only thing I might slightly disagree on with Paolo is his view on Brexit, in the sense that I think that the UK has been seriously obstructive for a long period of time. And in a piece that I've contributed to a new forthcoming edited book on EU collective labour law, which is edited by Beryl Tahar and Attila Kun, I've argued that it might actually be a lot easier to pursue the objectives in the pillar without the UK being there. Not to say that they haven't had significant allies in the past, so Poland, for example, in relation to collective labour rights under the Lisbon Treaty. But I do think that you may see the path slightly smoothed under the new Commission, unfortunately, and unfortunately for people like myself based in the UK. The other thing to pick up on, I suppose, again, is this idea of precarious work and the universal worker. And I do take Luca's point about the heterogeneity of self-employed work, but I was also persuaded, I think, by one recommendation from the ILO Global Commission on the Future of Work relating to a universal labour guarantee. And so for those not familiar with that, the commission, which was multifaceted, not really tripartite so much as kind of reflecting a whole range of different aspects of the world of work and different levels of participation, suggested that there should be certain rights which apply to everybody, regardless of what their formal employment status might be. And these would relate to the 4 core labour standards that we're very familiar with, but also in relation to working time, working hours, and health and safety. I think it could go further than that, but that's where they stopped. And I think what COVID has exposed is the real need for addressing core rights available to everybody, regardless of employment status. And reverting back to the debate that took place between the social partners at the end of the last session, the coronavirus pandemic has had particular effects on women at work and women in a range of atypical occupations, but also in the UK as elsewhere, care workers who are precariously hired in so many ways and made physically and economically vulnerable in this process. And I think that illustrates how important the universal labour guarantee, if applied to health and safety, would be. I do think that there is obviously forms of a broader competence problem in translating this through into action, and the difficulty of getting unanimity. But to some extent, crises can promote agreement where it might not have been there before. And I wonder, just as in the ILO on the Violence and Harassment Convention, you got protection for everyone in the world of work, maybe we're going to see some steps in the right direction in the future.
It's a very interesting but occasionally sore point. I couldn't agree more with what you said. Look, you don't know what you've done to this question thread here. It's just going mad, and I'm unable to follow the very interesting points that you are making and the very interesting questions that are emerging at the same time. I think I may be mistaken. There's a thread emerging from these questions in terms of what is the European pillar of social rights contributing to the move beyond the jobs. So is there something that you can see there as assisting with quality of work, not just in the traditional sense, but also in the more novel sense and novel challenges that technology and digitalization of work are presenting, from the intensification to, the right to disconnect was being mentioned before. Could it be that 3 years after its adoption, it's starting to show some signs of age, and it needs already an update in that respect? And the other question that is emerging is, I think, partly linked to that. There's a paradox. We are now in a situation where we have anything between 40 and 60 million workers in Europe that are on publicly supported income replacement schemes, but we're still struggling to come up with a coherent vision about minimum income in Europe, even though that was one of the policies and priorities identified by the pillar. So any thoughts on that for the last 10 minutes of our conversation?
Can I come back? Okay. So one of the things I left out of my last statement, which I think relates to this, is that actually if you want to improve meaningfully income gaps and precarity, the UK is a beautiful illustration of what happens when you do away with collective bargaining and you do away with forms of sectoral collective bargaining as well. So, for example, in relation to care workers, they used to have secure terms and conditions of employment and were hired through councils, and their precarity is something that's been generated in the last 25 years. And that's led to massive changes. And if we investigate how income is distributed, collective bargaining makes a difference. And secondly, I would say around tech and updating for tech, I think that it's time for a sui generis instrument that starts to address the needs of platform workers in a variety of ways. I think algorithmic forms of control are highly problematic and have to be addressed directly. And that is specific to digitalization. But it goes back to what Zoe Adams was saying about crafting solutions. You can have the legislative intervention and you can have the other forms of intervention, but you are going to need collective bargaining on the ground to ensure that you keep up with the shifts and the changes and the ways that are dynamic. So I think that there is scope for thinking about this in collective bargaining as well as interventionist terms, and that goes on to my concerns with universal basic income, minimum income that's provided by the state. I think I would trust many European governments with that responsibility, I can see in countries like the UK and the US this being set in kind of populist ways that sets the minimum income at too lower level to really subsist. And I am wary of suggesting that that is going to be sufficient. So I think that if I saw governments and democratic states as universally responsible, I would be a stronger advocate. But I worry about the fact that our basic social security and unemployment benefits are so woefully inadequate that it was never really proposed that in the context of mass unemployment in the UK that people would really exist on those. And I think that tells you something about the dangers of just opting for universal basic income unless you have a really responsible social democratic government.
Yeah, if it's my turn on this, I think Tonya already brilliantly touched upon many of these topics. I would say that, well, my take is the following. As usual, socio-economic problems are not single layered. They have, to many respects, they have many different reasons behind, and to tackle one social issue you must employ many different policy instruments. And I think that in this respect the pillar can possibly serve as a basis for this. What the Commission is currently doing is that they are trying, I think, as far as we understand from the outside, they are trying to employ as many instruments as possible. They did something on skills, they did something on IT, they did something on child guarantees, they are possibly going to do something on minimum income, even though I've also read in the comments here that they may do it more slowly than what was expected. But for minimum income, we should not forget that some member states already have in place forms of minimum income which tend to tackle at least some clusters of vulnerabilities in the labor market. I think that la baguette magique, so the magic stick, does not exist here. As usual, it's a multi-layer approach which is needed, and I think that the pillar at least is broad enough to accommodate a number of initiatives. I think that's it from my side for the moment.
Paolo, do you have some concluding remarks?
Yeah, very, very briefly. Again, it's absolutely true that we have not gone beyond the jobs focus to a certain extent. Although we have, even in the EPSR, we have some changes. We still have this model. And again, I'm very sorry I could not listen to some of the interventions in the morning because there's also this focus on growth that remains at the heart of the European institutions. I think the way forward, the progressive way forward, is to consider universal social protection as key, and not focusing on employment protection or supporting the unemployed, because we still, and the UK example is always very much in my mind, we're still very much framing social issues, although we're not doing it directly and explicitly, we're always framing them with reference to work. And of course, we know that social exclusion is often today connected to poor work opportunities. So I don't mean to deny the relevance of the link. We have lots of evidence that goes in that direction. But the universal basic income debate, and more broadly speaking, the post-growth debates, should take much more a role. It should be much more at the center of the policy debates and policy agendas, because so far, if we really want to push forward this social agenda and consider all the changes in the work environment, then we really need to be more creative. So far, we had a path that has been followed, and more recently, we could say that thank goodness that this path has been followed, but we need to add something to this path. We need to add universalism. We need to add the human rights, if you wish, at the end, because this is what we're talking about. So human social rights that will not necessarily be linked to the working status. And discourses as labor, working time reduction that were there 25 years ago with the Law Commission to a certain extent have to be considered much more carefully. And I know this is a bit provocative for trade unions because it goes in a direction that could be a bit problematic. But I think that it really has to be taken into account if we want to take the way forward seriously.
Thank you very much. Thank you all. That was really excellent and perfectly timed. It brings us to the very concluding part of today's event, which is where I should be offering some closing remarks on this extremely rich event. And I think I will try to do so over the next 10 minutes by reference to the very idea of European Pillar of Social Rights. And I'm taking my lead from Frank this morning, who said that it's a bit of a paradox to talk about European labor law because it's neither European, it's not really about labor, and it's certainly not just law. And in a way, when it comes to the European Pillar of Social Rights, a similar analogy could apply. But just like Frank, I'm in no way trying to diminish the importance of the European Pillar of Social Rights, just as he's not diminishing the importance and the contribution of European labor law, being a European labor law authority himself. So in terms of the EPSR being European, it's clear that its influence has gone well beyond the initial sort of geographical confines of the euro area that it was allegedly designed for. It clearly applies well beyond that hardcore of European Union member states. And in a way, it has had the great benefit of rekindling the process of European integration, broadly speaking, with other regional dynamics of integration, such as that exemplified by the Social Charter. There are references to the Social Charter in the EPSR, and the Social Charter clearly applies. It's a system that applies even beyond the European Union member states. There is a dialogue with the International Labour Organization that a lot of you have picked up during the day. The dialogue is just prompted by the EPSR and perhaps not really fulfilled by the measures that have been generated under the EPSR pillars so far. But clearly there is an attempt to go even beyond the Eurozone. I think what we're likely to see is perhaps a further attempt to involve subnational entities in the future in the implementation of the EPSR, regional entities. There are some references in the EPSR, in the regional EPSR document, to regions. I suspect that there will be an attempt to deploy the EPSR beyond the current levels of government into subnational entities. So if it is European, it's European in a very rich sense. The real problem for the EPSR, I think, is the term pillar. A pillar, and this is a point that has already been elaborated very nicely by a colleague, Sasha Gerben. Pillar gives us an idea of a static concept. A pillar, by definition, is it's static. It's there, designed to hold, to sustain something. But there's nothing more dynamic than the EPSR initiative, and this has emerged very, very nicely from today's proceedings. It's the effect of the EPSR span across a number of areas, across a number of forms of regulations of the EU, have involved the social partners like they hadn't been involved for a very long time, admittedly. And you have directives, recommendations, what used to be the open method of coordination being influenced by this pillar or by some of the pillars of the pillar. But clearly, it's a very dynamic instrument, and at long last, because we had been going through a period of Euro social sclerosis, as a lot of you mentioned throughout a number of the previous commissions, and not just the Barroso Commission, I think. In a way, one way of thinking of the pillar is that it's a mix between an old-style white paper and you can see that there hasn't been a white paper or a green paper since the 2006 green paper of on the modernization of labor law. So sort of decade plus later, after that green paper, we never had a white paper, fortunately, on the modernization of labor law. But when we get this pillar, but it's halfway between the white paper mode of policy making and a new charter of fundamental rights of workers, which we haven't had in, I would say, more than a decade. So, it was meant to act both as a policy document, but also as a blueprint for legislation. And it's clear that its influence spans well beyond hard law. For instance, we heard this morning that it has had a strong influence on the semester and on country-specific recommendations more markedly in the last couple of years. But that is quite soon after its adoption. And now it is increasingly intersecting with COVID measures and with the Recovery and Reform Plans program, but also with the annual Sustainable Growth Strategy, the European Green Deal, and social dimensions in the transition. We've heard in the previous session that while we're not going to have country-specific recommendations in 2021, there is still this big question as to what the country-specific recommendations in the fiscal areas that we've been told will be produced. There's a question about what it is that these country-specific recommendations in the fiscal areas will contribute and how they will interact with the social pillar. That is something really to watch very, very closely. Now, European pillar of social rights, when it comes to the social, I think social, it's really to be understood in the broadest sense possible, including, of course, labor law, but also social security legislation. And you have all made important contributions in your presentations as to the growing relevance of social security. But it has also been noted early on this morning that it still remains inherently linked to economic, both microeconomic and macroeconomic concerns, and not just related to growth, but also important macroeconomic questions that Europe has been grappling with for a number of decades, that have been put on hold for some time, we understand, by the COVID crisis, with the suspensions of the Growth and Stability Pact. We don't know how long this is going to last, and it may well be that while that lasts, the European Pillar of Social Rights can find greater voice in European policy making in the social and economic spheres. So a key question is to what extent the European Pillar of Social Rights is creating the space for measures to emerge that display a different policy mix between the usual tensions of social policy, micro and macroeconomic policies than the ones that have emerged or failed to emerge in recent years. I think the jury is out on this question. Some would say that the mere fact that we have had some instruments being proposed in the last few years, and important ones, is already no small thing. The Work-Life Balance Directive, the Transparency and Predictable Working Conditions Directive, the Social Security Recommendation for all its limitations, and now the new proposal on adequate minimum wages in Europe are all in a way linked to the pillar. And I think Lina has been right to say that the pillar also managed to interact with some early proposals that were already on the way, but really felt some influence, and a positive one, when the pillar was introduced. But it's also fair to say that some of you have pointed out that in many ways the pillar might have overpromised in terms of its original scope, certainly when it comes to the universality claim of some of its rights, and certainly when it comes to the level of protection of some of the rights that were identified there. Or at least, if the pillar didn't overpromise, perhaps legislation that has followed has slightly under-delivered, especially when it comes to questions of personal scope of application. But also, I would say, also beyond that, we've seen some interesting discussions emerging today around what the concept of an adequate wage should be in the directive compared to the original idea in the pillar. Now, rights. Well, obviously, it's generating hard law instruments, and obviously, it's triggering a number of important policy and soft law, OMC, we would say, related changes. But how about the European social dialogue? And how about collective bargaining, as Tonia and other speakers have been pointing out? When it comes to the European social dialogue, traditionally, labor lawyers in particular have said that a lot of it, and a lot of its success and even operation, was down to the idea of bargaining in the shadow of the law. So as long as there was a strong commission with an ambitious social policy agenda, social partners would be more keen to sit around the table and agree standards among themselves. But in the absence of that, you wouldn't have high levels of intensity of European social dialogue, or none at all, as it has happened for a good couple of decades until now. Now, an ambitious social policy agenda, such as the one contained in the European Pillar of Social Rights, with some caveats, of course, would have normally triggered a revival of European social dialogue across all the levels of interaction that European social dialogue has offered in the past. This has not quite happened, or quite not happened yet. And I think we need to ask the question, why has it not happened? Maybe we just there is just a time lag between setting out this ambitious reform agenda and ESD kickstarting again after years of being mothballed. On collective bargaining, I couldn't agree more with what the speakers said throughout the day, and Tonia summed up very nicely in her presentation this afternoon. Clearly, there are high expectations after the austerity decade in collective bargaining, and in particular, centralized forms of collective bargaining, sectoral collective bargaining being revived. I also see something positive in Article 4 of the Adequate Wages Directive in terms of capacity building, but the principle is great. In terms of the formulation of the requirements, I've been wondering for the past couple of weeks whether something very minimalistic, such as the UK statutory recognition procedure, could suffice to satisfy that level of capacity building demands that is placed on member states by Article 4. And I fear that it may well do so, in which case one wonders what the efficacy and impact of those very good points summoned up in the draft directive could be. Now, moving forward, and I'm really concluding here, I think as far as the future of the European Pillar of Social Rights, what I've learned today is that the single most commonly referred terms has been the term coherence. And could it be the European Pillar of Social Rights is already doing too much? you know, is there a risk of this pillar being a bit too fragmented, or perhaps not being sufficiently well served by the institutional actors that are dealing with it? You know, does it need more resources? Has it really outgrown even its substantial early ambitions? And does it require more resources in order to be serviced? I think the other question that is emerging is what is going to happen to the European pillar during the COVID crisis. We're seeing a further expansion of the importance and role of the pillar. I think the other third question, and this is already a short-term, but also medium and long-term question, is the dialogue between the European Pillar of Social Rights and the Just Transition Green Deal agenda. This needs to be clearly clarified further. And I can't help repeating myself on this point. The European Pillar of Social Rights hasn't yet delivered in terms of reviving European social dialogue and workers' participation in decision-making in Europe. And this is partly about the European social model. If the European social model doesn't have that at its core, then I don't think it's the European social model. It's some other model that has emerged in the last couple of decades. And I think there are big demands and big questions around the social of the European Pillar of Social rights. I hear what you're saying about universalism, but I think the big challenge for the pillar and for social Europe in the next decade is going to be universalistic while not being exclusively constrained by the fundamental or basic human rights debate acting as a cap on the ambitions of social Europe. And it's a paradox, the Charter of Fundamental Rights of the European Union hasn't been allowed to deliver the way it should. But we're already in a situation where you can only address the huge redistributive imbalances that we're facing if we move beyond fundamental rights understood as basic rights. And we need to be able to retain the universalism without being stuck in that sort of cage situation that often, it's a paradox because we still very much need fundamental rights at work to be protected as such. But the big redistributive questions that have been generated by 10 years of neoliberalism and 10 years of austerity, so 20 years in total, and are being exacerbated by COVID and by the huge demands on public expenditure that the Green Deal will impose on European countries in the next 10 to 15 years, if it has to be serviced properly, really asks for a different kind of response. And I think you have all made a number of extremely useful points, detailed points, on what that response should look like. And we can only continue to follow this conversation in the months to come on the basis of the excellent work that you in your individual capacities, but also through today's event, have done. So can I ask you to give yourself a big round of applause? You cannot see the audience, but I'm sure they would all join me in giving you a big round of applause. Thank you very, very much. And thank you also to our organizers, Maria, Kalina, and a number of other colleagues that have been involved, Aline, Philippe, in this important event for the ETUI. Thank you. Thank you. There is a possibility, I understand, there is a technological solution for continuing this conversation into smaller groups or not continuing it at all. And